Good afternoon, and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Today, our focus is on downsizing done right in an effort to adapt to a declining economy, changing technology, or an increasingly competitive landscape. Many companies are faced with the option of strategically restructuring their businesses through a reduction in force. While making the decision to downsize is never easy, the implementation process can be just as challenging for HR professionals and management. Our presenters today will walk you through the do's and don'ts of downsizing, helping you proactively address the many issues involved. Our presenters today are McAfee Taft employment lawyers Roberta Fields and Paul Ross. Both represent employers in all phases of labor and employment law, including litigation in state and federal courts, in arbitration proceedings, and before regulatory and administrative agencies. Much of their time is devoted to counseling employers on compliance with a broad range of state and federal employment laws and regulations, as well as educating management on best practices for avoiding disputes arising from the employer-employee relationship. So with those brief introductions, I now turn it over to you.
Okay, Brad, thank you as always. We appreciate all the work you put into these seminars and webinars for us, and I want to take this opportunity to welcome all of you to our most recent webinar. And let's talk a little bit here at the beginning about why we're here. Why are we dealing with this topic now? Well, unfortunately, we've been here before. If you were around and worked through the issues, the economic issues of 2008, you saw, as many of us did, the economic pressures of the workplace result in a number of employers making decisions to control costs or to reduce workforce in all kinds of ways in an effort to respond to those economic conditions. And we saw in 2008 a number of reduction in force opportunities that we helped clients with, and we're unfortunately seeing those same trends now. The recent decline in the price of oil has all kinds of energy companies really reflecting internally about their own costs and whether they have the right workforce to justify the workflow that they have coming in. And that set of economic conditions is resulting in a trickle-down effect that is really putting economic pressures on a number of companies that do work with and for these energy companies. And in addition to that, we have the same economic pressures that are always in place, such as changing technology and changing workforce needs, and the ordinary competitive pressures that affect all of us that are trying to do business in this day and age. And with all of those conditions being what they are, we have, again, the same as we had in 2008, a real trend towards the reduction in workforce issue. And, for example, I would tell you that since January 1st of this year, I've conducted personally 4 RIFs for 4 different clients, and several other of our labor and employment attorneys have done a number of other RIFs, some of which have been high profile, and you've read about those in the paper, and there are others being considered. So we felt like this was a good time to review the legal issues that surround layoffs and other cost-saving measures with the goal of helping you avoid litigation for those decision-making processes. And as you can imagine, with the cost of litigation is really the last thing you need when you're having to consider a reduction in your workforce. All right, so the first thing we want to talk about before we talk about the do's and don'ts of a reduction in workforce is to really think about what other options are available to you as a human resource professional and as a business executive that are somewhat short of the reduction in workforce route. When we're helping employers plan their reaction to economic conditions, we're always planning how we would explain this decision to a judge or to a jury. And one of the elements that we would always like to have when we're explaining a decision like this is we would really like to be able to tell the jury that before we laid off a single employee, before we disrupted the life of a single person or a single family, we really exhausted all the other options available. We were aware of and cognizant of the disruption that we were going to cause, and it was really the last consideration that we had in the economic reaction model that we had put together. So when you do that, for example, when you have considered other options first, you've eliminated waste, you've eliminated excess, you've eliminated and been creative in your cost-saving measures, and those things just simply weren't enough, the jury is less likely to criticize you for the way in which you chose the individuals that were impacted by a reduction in force. So what kinds of things can we consider? We can consider voluntary workforce reductions. That can include early retirement incentives. Those are certainly options that we would encourage people to evaluate. Sometimes a lucrative severance package or a lucrative set of benefits will encourage voluntary reductions, and obviously voluntary reductions are substantially less likely to end up in some kind of a litigation environment than a workforce reduction that's imposed upon people. Reducing employee hours is another option that has been a popular choice by some of our clients that are trying to avoid a RIF. The reduction of employee hours, while it is certainly helpful in controlling payroll costs, it comes with its own negatives. You're going to want to think about concerns that might follow with benefits. What is the implication of reducing someone's hours from regularly scheduled 40 hours to something more like 30 hours? How is that going to impact your benefit plan? How is that going to comply with the ACA provisions? Certainly something that has to be worked through, but it's an option. And I think most employees would prefer a reduction in hours over losing their job, obviously. There are other cost reduction practices that you can consider. This is more the category that we encourage you to evaluate where you have excess and where you have waste. Do you have, for example, expensive employee benefits that may only be provided to executive level or management level employees? Can we reduce those? For example, do we have really expensive event tickets that we pay for? Do we have expensive, gym memberships that we provide? Do we have a corporate jet? Do we have excessively high travel expense, entertainment expense? Those are all things that may have a material reduction on your overall costs and might prevent the termination of one or more employees. And it's certainly something that we would encourage you to put a lot of thought into before you get to the reduction phase. You can consider a hiring freeze. That is an option that, believe it or not, is something that employees or employers don't consider often enough. We may say that we have to conduct a reduction in force. We're going to reduce a substantial percentage of our workforce, but we have in another area of the company we're continuing to hire. And you got to seriously think about the impact that has on the theme of your presentation if you're ultimately having to defend your decisions. You can suspend the use of really costly employees like part-time or temporary employees that you may be paying a premium to a temporary service to provide those individuals for you. And the point here on all of this is that you simply need to be creative. You need to really examine thoroughly all of your practices and make sure that you have your expenses under control before you move to what is probably the bulk of your costs, which is your payroll operations. But if all else fails and you have to reduce your workforce and you have no other option, then we have a significant number of legal issues that we need you to consider in that process.
And, Paul, one thing to consider today, this is not the first time the oil industry has had a downturn with the result of laying off employees. The laws and regulations are much more complex today than in the 1980s when the oil industry went through this previously. Congress enacted the Older Workers Benefit Protection Act, and one of the reasons was in response to the number of companies that were laying off employees. And the vast majority, at least in Congress's opinion at the time, the vast majority of the people being laid off were over 40 and had potentially age discrimination claims. And so today we have, as an amendment to the Age Discrimination in Employment Act, what's called the Older Workers Benefit Protection Act. And what that law does is provide a set of requirements for waiving an age discrimination claim. let's say that you're going through a RIF and it turns out that you do have a large number of employees who are over 40 who are going to lose their jobs, then you certainly want to comply with this act because you want those employees to waive their age discrimination claims. So to get a knowing and voluntary release of claims under this act, there are certain requirements that you have to follow. What the statute does is give general guidance and some specific requirements as to what a court could find to be knowing and voluntary. For example, the release is supposed to be written in a language that an ordinary employee should be able to understand. You also have to give, if you're laying off more than one person, you have to give employees 45 days to think about whether they want to accept this separation package. Now, you don't have to give it to them 45 days before the last day that they work. In fact, you don't want to give an employee a release of claims to sign and then keep them on the payroll because, of course, most releases only waive claims looking backward. So if you have someone sign a release and then they work for you for another 10 days or 2 weeks or whatever, and during that time some comment is made or some action is taken that gives them a lawsuit, then your release has just become worthless. So the 45 days is not 45 days of guaranteed employment, but it's 45 days to consider whether to take the severance package and sign the release. After the 45 days, if you want them to release their age discrimination claims, you also have to give them 7 days basically to back out of the deal. They can send in their notice that they don't want to be part of the RIF and they're unwilling to accept a severance package. What that means is their employment is terminated, but you're not paying them severance and you don't have the benefit of a release. You also have to remind them that a release of claims is a legal document and they have the right to get an attorney if they want to. So as you can see, to waive an age discrimination claim, unlike gender, unlike sex, there are legal requirements that have to be followed or the release will not be valid. The EEOC has become active in criticizing release agreements, whether those release agreements are part of a reduction in force or settlement of a lawsuit. The EEOC has been extremely critical of releases that have requirements that prevent employees from going to the EEOC. So what a lot of companies and a lot of lawyers are recommending is that the release say that any claim to economic damages is waived, but the person signing the release does have the right to go to the EEOC. It's the EEOC's position that they have the right to investigate claims, whether or not someone has signed a release. So in sum, you can prevent the employee who has signed a release from getting a monetary settlement. You can't prevent them from complaining to the EEOC. Paul talked a bit about some voluntary measures to reduce headcount. With involuntary layoffs or a RIF, then you, the employer, are deciding which employees to terminate. And where you're making that decision, of course, there is a greater risk for a lawsuit. If the employees voluntarily leave, either through normal attrition, through retirement, or through enhanced encouragements to leave, there's less of a risk for a lawsuit. But where you're picking, the how matters, and the process that you go through matters tremendously.
Roberta, let me ask you a question. Your comments here are about severance agreements and releases that come along with severance agreements or that you would receive in exchange for a severance agreement. How would you advise an employer that suggested to you that they're not going to try to pursue a release at all? They just want to give severance out of the goodness of their heart, and they're not concerned about getting a release in exchange for that severance. Is that something that generally you're okay with or not?
Well, it's the employer's decision how they want to structure, but that would not be our advice. Where you're paying money that you're not required by law or benefit plan or some other union contract or employment agreement, where you're paying money you're not obligated to pay, it would always be my recommendation that they get a release of claims for that. I have had employers ask that question, and I have had employers who, as you indicate, were willing to pay the money without a release, but that would not be my recommendation.
Yeah, my suggestion on that would be, and I've seen this happen, that employers who do that often find that no good deed goes unpunished, and despite having given that severance pay, they get sued anyway. And nothing seems to make an executive madder than having given severance and then being sued by that employee. So certainly these issues about how and when to get a viable release are really important when you're considering a reduction in force.
You know, signing the release does not prevent an employee from suing, but if done right, it should be a bar to that lawsuit. And without the release, there is no legal bar to the lawsuit. So you've looked at alternatives, and it is the decision for your company that a reduction in force, involuntary, is the route to go. So what to do? What's your plan? Well, what we would recommend is that before you start, you do, in fact, develop a plan. Many companies look at this issue, don't get legal advice, decide that they need to reduce their head count, and they just pick people. And while that can be done in today's regulation-intensive environment, that obviously would not be our recommendation. So I would recommend that you develop a plan and you include your key leaders when you're developing that plan. How to do it, how to talk to people, how to communicate with people, how much of a cut you need are all important decisions, and they're business decisions that work better if you have buy-in from your key leadership. I also think that you get the most effective results when you involve key leadership in these decisions. I mean, the first decision you have to make is how much of a reduction do you need for your company to remain viable? And to understand that decision, you have to involve your business people. And I would say that we're going to talk about communication at the end of this presentation, but how you communicate the decision is as important as the decision. If you don't involve the right people in making the decisions, you won't have the acceptance that you need to get all of your employees, even those who don't like the decisions, to respect how the decisions were made and to accept that the decisions were made in the company's best interest. And Paul, I think you're going to talk a bit about keeping track of the hows and whys. And the reason that matters is if you end up in a lawsuit, you need to be able to explain how you reach the conclusion that A, a RIF was necessary, and B, the extent of the RIF was necessary to make the company an ongoing viable entity. And of course, the why is important. You need to be able to defend the decisions from why you're having the RIF on down to how you selected employees who would stay and how you selected the employees who would go.
Exactly. There really are two main questions that you're ultimately going to have to be able to explain. First, why a RIF? So those are the macro questions. How is the company performing? What are the economic conditions? What are your competitors doing? What is the price of oil doing to your business? Those are all the macro level questions that you're going to have to be able to answer. But on a more particularized level, with respect to every employee that was chosen for a RIF, you're likely going to have to explain why that employee was chosen, and more importantly, why someone else wasn't chosen. And the amount of information that gets thrown around and is considered in making these RIF decisions from the macro level to the micro level is so intense that without keeping that roadmap and without keeping a real keeping real attention to the plan that you've put in place to begin with and documenting the results of your conversations, it becomes almost impossible to have a consistent explanation for why you've done what you've done with respect to either group of decisions. And as you all know, what becomes critical in all employment law cases, and this is true even in reduction in force cases, is the idea of pretext, the idea that the explanation that you're giving does not make sense, or it's a cover-up for some other sinister motive that you might have. And when you have inconsistency in the explanation that's being offered by two executives, or by an executive and a manager, or any group of, or any person that's in the group of decision makers, if there's inconsistency in that explanation, a judge or a jury is very likely to conclude that somebody's not telling the truth. And if somebody's not telling the truth, they're probably hiding as I said, a sinister motive.
You make a good point. While including everyone in the conversation and disagreements in the room while decisions are being made should be expected, when everyone leaves that room, they should be on the same page.
Absolutely right. Collaborative decisions are important. It may be that Roberta and I are discussing people on our staff that need to be a reduction that we need to handle ourselves, and we may not agree at the beginning who is going to be the person that's chosen for a job cut. But at the end of the day, we have to be on the same page as to why the decision was made. Even if we had different priorities that we wanted to consider, we have to know at the end of the day why the decision was made. And obviously the buck stops with someone, and there is going to be an ultimate decision maker somewhere, but we really have to be clear internally as to why the decision was made. We have to be prepared to explain that to a jury. And as we're going to talk about in a minute, with respect to any severance agreement that we offer containing an age release, we're going to have to explain to a large degree to the people that are affected why they were chosen. And we'll talk about that in a little bit as we go. Now, in evaluating your planning, one important step that you have to consider is what we call limiting factors. There are a number of factors that might come up in the employment context that will limit your ability to choose certain people. Or if you choose those people, there will be additional consequences for having chosen them that you need to be prepared to accept. For example, some employees have written employment agreements. If they have those agreements, you might have contractual obligations to provide severance benefits that are different than what you intend to offer to the affected group. You might also have some ongoing compensation requirements that you have to meet because the person is not being terminated for cause as that's defined in the written agreement. You may have to continue that person's salary for the term of the contract and then offer severance over and above that amount. So those are factors that you need to make sure that you're considering when it comes to employees with employment agreements. If you have a union contract at play, there is very likely going to be provisions in that agreement that govern how you select who will be reduced and might provide bumping rights. There are other things that are contained in union agreements that will certainly impact your ability to choose individuals for reduction in force, and you need to make sure those are being considered before you start identifying individuals. Past practices or history are another good example. When you've got a practice of providing severance and you deviate from that practice in some way, you open yourself to claims for discrimination. So it may be that you have a valid reason for that. Maybe the economic conditions have changed to the point that you can no longer maintain that practice in the way that you've done it before, but you certainly have to consider and evaluate that before you make a decision to go forward.
Of course, the best practice here would be to adopt a specific plan, a specific severance plan for this downsizing. But to your point, if you've offered more in the past, that's something you need to be aware of. But a separate plan for this year's 2015 downsizing should protect you. Absolutely.
And obviously, as always, we really encourage you to think about the personnel policies that you have put in place. Once you publish a personnel policy, an employee handbook policy, you're I wouldn't say that you're married to that policy because you have the ability to change those things when circumstances dictate that that's necessary, but you can't ignore those. You're going to have to be prepared to explain why you're deviating from that policy or why you're changing it. It can't be something that just gets ignored in a process like this.
Or if someone relied on it, you may leave yourself vulnerable to an implied contract cause of action. So head that off at the pass, too.
And then the last thing to consider in those limiting factors, remember that all of your benefits, especially your defined benefits, are going to have implications in determining what is owed to employees that are RIF. You're going to want to consider what those plan obligations are. You're going to want to consider whether you have COBRA obligations. You're going to want to make sure that those communications are a part of the documentation that you're providing to your RIF employees. There really is quite a bit of information that has to be thought out, and this is why we really encourage employers to get us or their legal counsel involved way back at the beginning of this decision-making process so that we're not trying to scramble to put together a packet of information in a week or two that really needs a month of planning.
We've talked a bit already about looking at alternatives to job loss. This is just a little bit more information about alternatives. Sometimes the economy, your need to reduce may be quick, and sometimes it may be slow. Normal attrition, if you have an aging workforce, you may have enough people who are eligible for retirement, and your business needs may not be slowing at the rapid pace that some oil and gas companies are finding, and you may be able to you, of course, can't force people to retire. You certainly can't ask people about their retirement plans. But if you know you have an aging workforce that's coming close to, then perhaps you freeze hiring and you let those people leave. But that's a timing issue. You know, if you have the luxury of waiting on people to leave voluntarily, that's obviously something that has less legal risk. You're not likely to be sued for that. So it's something to consider. Incentive programs are, again, people leaving voluntarily, but you're basically making it worthwhile for them to leave, whether you're offering additional benefits to bridge them to Social Security, whether you're amending your retirement plan to, offer an additional few years depending on where they're at, whether you're, somehow offering a significant financial benefit, and you're looking for volunteers. You're not offering severance benefits to people that you've chosen, but I've seen this work where companies had significant reductions they needed to make, and they thought they would just see if they made the pot sweet enough, if enough people would voluntarily leave. It does work. It's a cost-benefit analysis. You have to decide if it's something, how much of an incentive you're going to have to offer and how many people you need to leave and whether it's worth it. I've also seen companies close down briefly plants or locations or offer furloughs to employees. It's something to consider where you don't really want to lay people off, but you have sold the corporate jet, you've given the Thunder Suite to someone else, you've looked at other ways to reduce your cost, and now what you're looking at is you're down to employees are your largest cost, and you know that's where you need to take action. You've decided to reduce your head count. These are some ways to look at alternatives to doing that. You can eliminate your temporary employees. Of course, whether you can successfully do that depends on how much your business has dropped off. But if they're a temporary employee and they've come to you either by way of contract or through an agency, by eliminating those employees, you're not actually reducing your own company headcount, but you should be cutting costs. So these are just suggestions to look at that, may or may not work. But we realize that at the end of the day, to reduce your costs, you actually may need to have a RIF. So you're looking at having a reduction in force. Having considered everything else, this is the way you feel you need to go. Without stating the obvious, if you use an objective process, you are less likely to have a successful employee challenge to your process. And by objective, we mean, for example, seniority. If you cut the people with least seniority, then you're not picking them based on age or race or gender. You're picking them based on seniority. So that's an objective process that makes it more difficult for an employee to challenge, to file a lawsuit. Now, obviously, if you're a union shop, you have to check your collective bargaining agreement, and this may be the way that you're required to go. But even if you're not a union shop, it's perfectly legal to use seniority as your method for reducing headcount. So it's an easy way to do it, but you may not retain the right people. You may have your less senior people who are perhaps your best performers, and this may not be a method that works for you. By an objective process, when we talk about productivity, we're talking about something measurable, not your best people who got the best performance appraisals, but for example, in a factory, a production line, or in a call center where you keep track of the number of customer calls successfully handled by employees. It would be something measurable, and you could legitimately use that as your measure for reducing headcount. Again, it's a relatively easy process, but you may not retain the right people. Most companies, I find, use some combination of objective and subjective process. They want to keep their best people, and the way to do that generally is some combination. So if you're wanting to keep your best performers, you often look at performance appraisals. Well, that may seem objective, but if any of you are involved in HR or involved in evaluating employees, you know that if you have a variety of supervisors, then there's a high likelihood that that variety of supervisors bring their own biases, feelings, judgments to the table when they're evaluating their employees. For example, I've seen companies where there are some supervisors that give everyone, on a scale of 1 to 5, give everyone a 5. They feel really good about their group. You have other supervisors that no matter how hard you work, people in that department just can't score more than a 3. So to just use performance appraisals, while legitimate, I think I would discourage using that as the only subjective measure, and I think what I would do is get people in a room and who know the people and have them evaluate the people on a whole new scale, and then use performance appraisals as a way to back check. I think Paul's going to give us more information about the method, but to get you in the ballpark, we wanted to introduce objective and subjective. Now, of course, if you use any type of subjective process, you're more likely to get complaints, and you may have less control over who the people are and leave yourself more open to complaints of age discrimination, gender discrimination.
Yeah, I think the important point to discuss when you're talking about the criteria that are used to select individuals for a RIF, you have really unlimited discretion about what those criteria are. They may be, a certain criterion may be more important to you than it is to another employer, and you have flexibility in determining what those criteria are, as long as they're not protected characteristics that are driving your decision. Like
we're keeping all the men won't work.
Exactly. But when it comes to your flexibility in using subjective criteria, as Roberta said, most employers use a combination of the subjective and objective criteria that are most important to them in making the decision. Hopefully, we're not identifying those criteria to justify pre-selected people. Hopefully, we're identifying those criteria and then letting those criteria determine who the right people are to be picked for retention and who are the right people to be picked for reduction. But here are some tips on how to avoid criticism of using subjective factors. Number one, use a diverse selection of decision makers. It's really good to have a panel of people that make the ultimate decisions on who is reduced and who is retained. And that panel can, in the first instance, determine what the criterion are. In the second instance, they can determine how those criteria are weighed, and hopefully they can apply those criteria in a consistent way. So for the example of using attendance and punctuality as a factor, perfectly appropriate factor, we want to just make sure that we're using my attendance record in the same way that we might be using the attendance record of one of my coworkers, so that we're consistent in how we value that criteria in the process.
For an example of a higher level job, you might take, a director level, a vice president level, and you might say, what are the skills, traits that are best for this performance? And you might have team building, ability to communicate well, a consensus builder. Those sorts of criteria would be more important at a higher level. And then you involve individuals who know those people. I think that's hugely key.
Absolutely right. The committee or the panel that you use to make those determinations really has to include the individual that has that ground level knowledge of your employees, the day-to-day supervisor or the day-to-day manager that actually works with those people, so that the feedback on those subjective, touchy-feely type criteria is actually legitimate and meaningful feedback, and not simply the one-off incident that the VP observed 2 years ago that ultimately results in Paul being classified as someone who can't communicate or isn't a good team builder. We really need to make sure we have the people on that committee or on that panel that know what is Paul like over that entire 2 years time frame, not just the one incident that the VP may have observed. Now, one thing I would also encourage you to think about that's not on here, just from experience, I would tell you that sometimes employers try to take subjective measures and turn them into something that looks subjective by taking a touchy-feely criteria and turning that into a 1 to 5 rating scale and asking the panel of people to evaluate Paul's team-building skills on a 1 to 5 and Paul's communication skills on a 1 to 5. And those types of processes are helpful if there is true meaning behind those ratings. But if those ratings are themselves just subjective numbers, and there's no guidance to the committee in how to assign a 1, how to assign a 5 on a given topic, then it's not helpful. And in fact, it starts to be something that's even more easy to criticize, because there's no standards for determining how to rank someone between 1 and 5 on a given criteria. And so while I see the value in trying to objectify the process, you have to make sure that there really is an objective element to it, and it's not really a gut feel process. If you're asking your panel to evaluate people on a gut feel, and Paul may get a 1 and Roberta may get a 5, and there's no real standards as to how to define that, it's not going to be meaningful as an explanation tool. It's, again, as we mentioned earlier, it's extremely important that the panel reach a consensus on decisions. That does not mean that there has to be unanimity in agreement in every case, but there has to be a consensus reached, and there has to be documentation of why the decision was made. That will ultimately be something that we have to communicate to employees in the termination documents. What were the things that we considered that resulted in your termination? And if you're not documenting that process, it becomes very easy for there to be inconsistencies in what people on the panel say was the decision-making process.
Plus, I think, to be perfectly honest, unless you're a really tiny company, you forget why someone scored higher than another. So in the method that we're basically endorsing here, where you take a job and you write out the traits and qualifications for it. You have a group of people rate the pool of applicants or potential candidates on those traits and scores. If you don't keep track of the comments and the scores, you won't have the ability to defend a claim by someone who didn't get the job.
That's right.
And then all this is sort of for naught.
That's right. And then finally, one of the things that we often see employers overlook or make a mistake about is that even when the process for identifying people is as good as it can be, it's as close to perfect as can be done, we've really done a good job of documenting why we've done it and the factors that we considered in reaching our conclusions, sometimes employers fail to do an analysis after the fact. The first run through in selecting individuals for a RIF needs to be evaluated for its impact with respect to protected characteristics. We need to take some analysis and look at the demographics of our workforce before and after the proposed RIF. And if it turns out that we have some real disparate impact with respect to individuals of age or individuals of color or one gender or another, then we really need to go back and analyze our process and make sure our process doesn't have inherent biases that we didn't identify. It may be that we make no changes after having done that analysis, but we need to be able to look the jury in the face and say, we analyzed this after going through our process. We analyzed the impact. We saw that it had an impact on a particular group. We went back, reevaluated our process, made sure that we didn't have biases and that all of our decisions were legitimate and non-discriminatory, and we decided not to change the process and went forward with it. Or we made changes to the process to make sure that we did away with that bias and resulted in a less impactful group of selections on that particular classification. That demographic analysis and the ability to explain to the jury that you were cognizant of it and that you made extreme efforts to make sure it didn't happen, or that it didn't happen without inappropriate biases, is really, really important.
To be clear, I think what the disparate impact analysis requires you to do once it's made, if you look and you do have a disparate impact of a minority group or females or people over 40, I think that it requires you to take a look. It doesn't require you necessarily to make a change. But I've been involved in RIFs where we ran the numbers and saw that we did have a disparate impact, and we looked back and there were places where the disparate impact was not enough females. Too many females were being cut. And we looked back, and there were places where male and female were almost a dead tie for certain positions. And so we made changes based on that. So I don't want people to think they have to make a change. If you followed the process and you have a business reason for the people that you picked, you know, that business reason, that is they have better skills, you know, in a certain area, is a good business reason for the pick, and it makes it defensible. But you do want to do this look back with the numbers to see if you've missed some close calls.
And you want to make sure that not only that you have a business reason for what you've done, but that you're confident that biases haven't encroached in the process in some way to color that business reason in a negative way.
Good point.
You know, you want to make sure that your motive is clean, I think is the best way to put it. And once you reach that conclusion, you may not make any changes despite the fact that you have an imbalanced impact on one class or another. All right, let's move along now to talk about the legal issues surrounding releases and severance agreements. We've touched on these a little bit, but we want to give you a little bit more information on these. The first of one is to talk about what the EEOC considers to be the requirements of an enforceable release of claims. And as we mentioned before, the release of claims couldn't be more important in a severance agreement. That is the key element of what you're getting in exchange for your severance when you have to reduce your workforce. And it's important that you make sure that the release is done correctly so that you don't end up giving severance in exchange for a release that you can't enforce anyway. Now, the EEOC takes the position that all releases have to be knowing and voluntary, not just releases of age discrimination claims. All releases to be enforceable have to be knowing and voluntary. They don't give us a crystal clear explanation of what that means, but what it means is you want to avoid legalese to the extent that you can. You want to give the employee a reasonable time to consider the release and evaluate whether or not they want to sign the release and have an opportunity to ask questions if they decide they need them, whether they're questions internally or to an attorney that they may hire at their own expense. But you have to satisfy that bare minimum for all releases of claims in order for the EEOC to consider it to be valid. You also have to make sure that your release does not include or attempt to include waivers of future claims. Any release that attempts to waive claims for events that have not happened yet in the future is unenforceable. And you run the risk of having your entire release invalidated by including something like that. You also, as Roberta mentioned earlier, you have to make sure that your release does not expressly forbid an employee from going to an administrative agency despite their signing the release. They might sign the release, waive their claims, and still have the right to go to the EEOC and pursue a charge of discrimination. Again, as Roberta mentioned, they can waive their right to recover for that, but they might still pursue administrative remedies at the EEOC level, and that is permitted as far as the EEOC is concerned.
What that means is the EEOC can come to your place of business, talk to people, interview. The person who signed the release can't get money, but the EEOC could still require you to post notices they could still be involved in your business.
Absolutely. Now, with respect to claims involving age discrimination, as Roberta mentioned earlier, there are significantly more requirements on a valid release if it attempts to waive age discrimination claims under the ADEA. If you intend to include a waiver of age discrimination claims, you have to satisfy the Older Workers Benefit Protection Act. That means an express requirement that the document be written in plain language. You will notice if you've gotten severance agreements from us before, there's sometimes a significant difference between what a release looks like if it's written for an employee over the age of 40 versus what it looks like for a younger employee. This is why. Once we start including claims under the Age Discrimination Act, we have to write it in plain language. In addition to that, we have to affirmatively tell the employee that they have the right to seek an attorney. A number of clients will ask us when they're looking at a draft document, can we take that out? I don't want to encourage my employee to take this to an attorney. They're going to come back and argue that they want more severance. Unfortunately, we can't. It's required that be in there, and many employees don't take advantage of that, but some do, and I think that's the purpose of the law. But again, if you want your release of age discrimination claims to be enforceable, you'll include that. In addition, you have to provide specific time frames, as Roberta mentioned, for the employee to consider that release. For an individual termination, it's 21 days. For a group termination, it's 45 days. If you don't provide the employee that window of time to evaluate and consider the agreement, it won't be enforceable.
Doesn't mean they have to take it.
That's
I've
right.
had clients say, do they have to wait the 45 days? No, they can sign it the next day as long as from the day you gave them the document until the day the offer is revoked, they have the 21 or the 45, you're fine.
Correct. And then in addition to that, after they sign the agreement, no matter whether that's 1 day after they got it or 45 days after they got it, they do have 7 days to change their mind. They can revoke their agreement. What we typically encourage employers to do is withhold the severance until that 7-day revocation period has expired. That way we don't have a situation where an employee takes the severance pay, cashes the check, buys the new car, and then revokes their agreement. Good luck getting it back. We can certainly try, but employees often will burn through that money before we have a chance. All right.
I think the next slide is what can go wrong. We could have simplified the title, couldn't we, Brad? What can go wrong? Well, claims of discrimination, unfairness is really discrimination, I suppose. Despite your best efforts, you have employees who don't want to sign a release agreement. They don't agree with the fact that they were selected, and they believe they were selected for an impermissible reason because they're a member of a protected group. So they're a minority, they're a female, they're over 40, and they believe that's why they were picked. You might be faced with a claim of discrimination. That's why what we've talked about is so important. If you've followed the process, if you've documented who you picked and why you picked that person, then it doesn't mean you won't get sued, but you should have a good defense to any lawsuit. The release itself, frankly, should be a good defense in many courts to claims of discrimination or unfairness. But the possibility of getting sued once you've conducted a RIF or reduction in force, it obviously exists. Disparate impact, if you're not familiar with the concept, it's the idea that a process or a rule on its face looks fair, but the way it's implemented is not fair. So what this would be, the classic case is the electric company in the South that refused to hire janitors that didn't have a high school diploma, and the court struck that down and said it looks fair and reasonable to have a requirement for all of your employees to have high school diplomas, but there's really no good reason to require that when they're your janitor and it's having a disparate impact on minorities. And so the rule was struck down. Well, in a restructuring or a RIF concept, you may end up, once you've run your numbers, with a disparate impact on a protected group, age, race, gender. And what that means is if something really goes wrong, you may have a class action lawsuit from that group that feels they were unfairly impacted. Hopefully at this point you have, again, the releases and the process to protect what you've done. You also have to check, we've talked a bit about this, union contracts and employment agreements to make sure that you're not violating obligations under those. Another possible place for getting a claim is a termination of an employee who's on medical leave or military service. USERRA is the statute that covers military service, and FMLA is the medical leave statute. Under those statutes, employees who are off on protected leave have the right to have their job when they come back. Well, there's an exception for a reduction in force. If they would have been employed, that is, they would not have been on the protected leave, but would have been sitting at their job, and you would have picked them anyway, then you can still pick them, even though they're on leave. An ERISA claim is under, I think it's Section 510 of ERISA. You get sued because I believe I've been terminated. You had the goal of interfering with my retirement plan or some other ERISA plan rights. An example of this would be I am 2 weeks away from vesting in my defined benefit plan, and you had your RIF and you let me go. And I've actually had clients who didn't check this information on people they were about to RIF. It's extremely important to check retirement status on employees you're about to RIF. If they're 10 days away from, if you have a few employees who are 10 days away from vesting in the plan, you need to figure out how to make that work, if at all possible, because you're just setting yourself up for a claim under ERISA. What they'll say is, you terminated me because you didn't want to pay my retirement benefits. And you'll say, no, we terminated you for a legitimate business reason, and in all likelihood, it'll be a federal judge that makes that decision. So possible retaliation claims come up when you terminate somebody who's filed an EEOC claim or who claims they've been a whistleblower. Again, your legitimate business reason for terminating should be your best defense. And then post-termination payroll issues. If you're an employer who operates in several states, some states, I think maybe Montana's one, have rules where you have to pay the same day you terminate. I think theirs is within 4 hours. I think Texas has a within 6 days. So Oklahoma, I think, allows for 2 weeks. But if you're operating in a state that has a different law, you have to be aware of that. There's no reason to violate a law unnecessarily.
All right, and then one other legal issue that comes up quite a bit, we're going to spend a minute or two on. We could talk for an hour about the WARN Act, but just to make sure that you're aware of it, the WARN Act requires that in the instance of a plant closing or a mass layoff, and you can see how those things are defined there, we have to provide 60 days notice to our employees before they are released from their job. That basically means they will have paid and benefits for that 60-day period between the notice and their last day of employment. There's certainly there's a lot to the WARN Act that we would need to discuss, but we want to make sure that employers are aware of their obligations to provide that notice both to the employees and to a local government agency and to any union that might be affected well in advance of the plant shutdown or the mass layoff. And there are significant obstacles to any attempts to avoid that obligation. And so it's something that you will need to discuss with your counsel before you engage in a RIF.
I think the real thing to watch out there for is the 90-day look back. A lot of companies will lay people off and not anticipate that they're going to lay more off in 30 days, and they run afoul of the act without intending to. On communication issues, I think the big thing here is to have a plan. The announcements of mass layoffs can obviously take a serious toll on your employee morale and productivity. So you should really look up front at formulating a communication plan for both the employees that stay and the employees who are going to end up leaving. One of the most important things here is never lie to an employee. I once defended a company that got sued after a downsizing because employees believed they were lied to. The downsizing was put into place so quickly, employees who had asked whether a downsizing was coming 60 days prior to the announcement truly believed that they had been lied to because the company was able to put their plan together so quickly. So to sum this up, I think you have to get a plan. I think you have to be honest with employees, never lie. If you're not prepared to announce yet, just say, we are looking at options. We will announce to you once we have a plan in place. Don't say no comment. Don't keep people boxed out. They feel like they're not part of something. Then you've lost credibility, and you may lose employees you didn't intend to lose.
Yeah, and in addition to losing credibility, anytime you have any kind of inconsistent message or any inconsistent statements between two individuals or even inconsistent statements with one person in the future, those inconsistent statements can be interpreted as being pretext, as being a cover-up for what your real message was. In addition, with respect to communications issues, it's really important to not lose sight of the personal nature of what you're communicating. It really is, even if it's your last straw, even if it's the last effort that you can make to control the costs in the economic climate that you're in, you're still disrupting the livelihood of a number of people and their families. And so when you're communicating the RIF decision, it's important to be able to communicate the business need for the decision, but it can't be a business issue. It's not a business issue to the people that are losing their job. It's a personal one. And I think the message really needs to incorporate that feeling as you go and communicate the idea that a RIF is happening.
I've had RIFs for clients that took a lot longer than the one I mentioned previously, and I think it is really important where you've already announced it to keep employees updated of your progress so they'll feel included.
Absolutely. A couple of other key points to touch on just briefly, and then we'll wrap this up. It's important for you to think about when you're considering the communication plan and when you're developing your strategy for communication, you need to think about not just internal communications, but external communications. How are we going to portray this in the media? How are we going to address the security issues that might come along with that, both internal security and PR security that might be involved? And then it's important that we manage that message and manage the communication of the business purpose for the message without losing sight of the personal impact that it has on all of our employees, both the ones that are staying and the ones that are leaving. That will pretty much wrap it up for us today. I want to thank you all for your time and your attention today, and I'll turn it back over to Brad.
I want to again thank Roberta Fields and Paul Ross for presenting today's webinar, and on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar. See you next time, and have a great afternoon.